discussion group. Firstly, we would like to acknowledge that we're meeting on the land of the Australain Nations and pay our respects to their elders, past and present. We would like to thank the University of Melbourne Energy Research Institute, our Zero Carbon Australia project partners, for this great venue. For anyone that hasn't been to one of our discussion groups before, Beyond Zero Emissions is a climate solutions, research and communications organisation. Our goal is to transform Australia from a 19th century fossil fuel-based economy to a 21st century renewable powered clean tech economy. Our projects include the Zero Carbon Australia research, Repower Australia talks, media work, education programs, street stalls and more. This discussion group, is a forum for climate change solutions with presentations by experts in the field and is held on the first Monday of every month, except next month. This month, we present the fossil fuel resistance, intellectual property, climate activism, and culture jamming. Our speaker is Dr. Matthew Rimmer, an Australian Research Council Future Fellow working on intellectual property and climate change. He's an Associate Professor at the Australian National University, College of Law, and an Associate Director of the Australian Centre for Intellectual Property. He joins us to analyse specific stunts by the yes men who impersonate big-time criminals to publicly humiliate them. 2013 has seen a series of similar battles over climate change, culture jamming and civil disobedience, supported by the likes of fossil fuel divestment champion Bill McKibben. The courts have been forced to tackle complex legal questions involving climate activism and its place in the politics of climate change. Matthew will discuss international debates over civil disobedience, identity correction, hoaxes, impersonation, climate activism and culture jamming. We have tonight via Skype Matthew Rimmer. Would you please welcome Matt?
Good evening, Melbourne. Tonight I'm going to talk about the fossil fuel resistance, intellectual property, climate activism and culture jamming. Just a little bit about my background. At the moment I'm doing our Australian Research Council Future Fellowship on intellectual property and climate change. And I've been at the ANU College of Law for a dozen years now, doing work on a variety of different kind of areas of intellectual property. I really started out doing work in the 1990s on copyright law. And at that particular time I was very kind of interested in some of the battles that took place in relation to parody and satire and hoaxes. So my current interest in some of the semiotic, symbolic battles over climate change kind of in part kind of stems from that early work. So I've done a lot of work on copyright law. I wrote a book called Digital Copyright and Consumer Revolution. I've done work on intellectual property and biotechnology and access to essential medicines. I was part of the campaign for plain packaging of tobacco products in Australia and pushed for tobacco divestment. But at the moment I've been doing a lot of work on intellectual property and climate change, looking at the different kind of varieties of intellectual property and the sorts of issues that they raise for clean technologies and renewable energy. So I kind of did a book really looking at some of the battles over patents in relation to fossil fuels and clean tech and renewable energy. And at the moment I'm kind of busy doing work on green trademarks, greenwashing and environmental activism. And I guess tonight's talk is really kind of a selection of that particular work in terms of looking at some of the battles that have kind of taken place between intellectual property rights holders, particularly those of fossil fuel companies, and their battles with environmental activists and climate activists. So, to kind of introduce my topic, I think it's kind of useful just to kind of begin with the kind of the title of my topic, the fossil fuel resistance. The title really kind of comes from an essay by Bill McKibben. Bill McKibben was really kind of talking about the concerted efforts to tackle the fossil fuel industry. And he kind of noted that after decades of scant organised response to climate change, a powerful movement is quickly emerging around the country and around the world, building on the work of scattered frontline organisers who have been fighting the fossil fuel industry for decades. There's no charismatic leader and no central organisation. It battles on 1,000 fronts. But taken together, it's now big enough to matter, and it's growing fast. It goes on and says, no movement this diverse is going to agree on a manifesto, but any reckoning begins with the idea that fossil fuel is dirty at every stage, and we need to put it behind us as fast as we can. For those of us in affluent countries, small shifts in lifestyle won't be enough. We also need to alter the policies that keep this industry fat and happy. For the poor world, the much harder goal is to leapfrog the fossil fuel age and go straight to renewables, a task that those of us who prospered by filling the atmosphere with carbon must help with for reasons both moral and practical. And for all of us, it means standing with communities from the coalfields of the Appalachia to the old soaked Niger Delta as they fight for their homes. They've fought longest and hardest, and too often by themselves. Now that global warming is starting to pour seawater into subways, front lines are expanding and the reinforcements are finally beginning to arrive. Climate activism kind of takes on a variety of different forms. I guess tonight I'm kind of particularly interested in forms of climate activism that draw upon a range of very kind of cultural strategies in terms of parody, satire, culture jamming, remixing, engaging in ad busting. And I guess there's a kind of a long and proud tradition of using such techniques previously in terms of political activism. So, you know, in Australia back in the 1980s, doctors used to join the group Bugger Up, which would graffiti and deface tobacco billboards and change the meaning of tobacco billboards. But such movements became much more organised with Adbusters from Vancouver. Adbusters is kind of very keen on taking media advertisements and subverting them and changing their meaning. And Naomi Klein, who is now on the board of 350.org, in her book No Logo, was very kind of influential in kind of talking about the power that exists in relation to the iconography of trademark holders and the way in which various groups, particularly fair trade groups, tried to use those logos and kind of turn them back upon themselves, as it were, use the kind of powerful symbolic value of those logos and those brands and those trademarks to engage in criticism of companies. And I guess the range of tactics in some ways has kind of become very formalised. There's a recent book called Beautiful Trouble, A Toolbox for the Revolution. Subtitle from the people who bought you, the yes men, billionaires, Bush, etc. This book was kind of assembled by Andrew Boyd, and it really kind of surveys a range of different tactics and strategies and techniques that could be used by activists in terms of taking on particular political issues. But a number of the activities really kind of focus upon civil disobedience in relation to climate change and culture jamming in relation to environmental issues. So in tonight's talk, I really want to kind of do a little survey of 5 diverse case studies involving clashes between the fossil fuel industry and climate activists and environmental activists. So first of all, I'd like to kind of talk about Greenpeace's creative confrontations, particularly with the Free Arctic 30 campaign in the news at the moment. Second, I'd like to have a look at the battle between the Yes Men and the United States Chamber of Commerce and the kind of long-running kind of lawsuit that took place after the United States Chamber of Commerce sued the Yes Men. I recently had a good chat to the Yes Men's lawyers, the Electronic Frontier Foundation in San Francisco. My third study looks at the Youth for Climate Truth, who kind of put out a hoax press release from the Koch brothers, and in return were subjected to legal action by their industry. And to kind of wrap up the evening, I'd like to kind of look at the battle over bidder 70 and the current controversy in relation to Jonathan Moylan and the Whitehaven coal case, and the battles in relation to civil disobedience in respect of that matter. So, to summarise, I'm going to look at Greenpeace, the Yes Men, the Youth for Climate Truth, Bidder 70, and Jonathan Moylan, and their various confrontations and encounters with the law. So to begin with, I'd just like to kind of talk a little bit about Greenpeace and their creative confrontations over the years. I mean, in some ways, Greenpeace is a very kind of long-standing institution, but they've also been very kind of keen on drawing upon strategies from elsewhere. So Greenpeace has kind of been, particularly over the last decade, very interested in drawing upon some of the ad-busting strategies of the ad-busters and the no-logo movement. And this really first kind of came to a head in 2002, in which Greenpeace France took on ExxonMobil, and they essentially used on its website a parody logo of the ExxonMobil two X's together, and they kind of replaced the X's or the SOs with dollar signs. And in that kind of particular matter, ExxonMobil sought to obtain an injunction and almost $100,000 for damages in a trademark lawsuit. And I guess it was a very kind of important clash. The Paris Court of Appeals decision considered the complaint in relation to infringement. The Court of Appeals held that even if parody is not allowed in trademark law, Greenpeace is nonetheless entitled to exercise the fundamental right of expression. In this case, there could be no confusion between the trademark of ESO and the Greenpeace slogan, Stop ESO. The Court of Appeals concluded that Greenpeace's activities remained within the limits of freedom of expression and did not violate ESO's trademarks and trademarks of ExxonMobil. And over the last decade, I guess Greenpeace have been involved in a number of confrontations with companies, particularly when they've been kind of engaging in hard-hitting criticism of their practices. And Greenpeace kind of nicely kind of commented upon their creative confrontations. A couple of years ago, when there was a big kind of controversy about the Stop Online Piracy Act in the United States. It was a very kind of punitive, draconian law which would give intellectual property owners very extended rights to bring actions in respect of infringement, both in respect of copyright law and also in relation to trademark law. You know, Greenpeace kind of commented upon this bill and said, you know, under the proposed US censorship laws, websites could be shut down because we spoofed VW's logo. In the history of bad ideas, the concept of giving corporations the right to censor the internet has to rank among the worst ever. But that's what the impact of the two bills, SOPA and PIPA, recently introduced in the US Congress, would be if they or anything like them were enacted into the law. And it's causing a righteous ruckus among free speech activists around the world. And in solidarity with other major sites like Wikipedia and Boing Boing and Reddit, Greenpeace websites went dark to kind of protest against these particular bills. And such was the kind of the outrage against the Stop Online Piracy Act. The United States Congress had to change its positioning in terms of the bill and withdraw that bill and its companion bill. But Greenpeace had some interesting things to say about its own kind of strategies in terms of dealing with intellectual property rights of companies. It kind of noted at Greenpeace we've managed to put some judo moves on some mighty corporations by leveraging their own advertising budgets against them. whether it's spoofing VW's most expensive Super Bowl ad of all time, spreading the word about a spoof of the American Petroleum Institute support for the Keystone XL's Tarzan's pipeline, creating a Kit Kat ad that illustrates the rainforest destruction inherent in palm oil manufacture, or parodying the Apple.com website to push for better e-waste policies. We've rigorously exercised our right to free speech, and in freely speaking out against corporate abuse of the environment, we've won many a campaign victory. They kind of noted we use corporations' own language, their own marketing, their own strength against them, which is sometimes the only way that an entirely supporter-funded operation like ours can afford to put a spotlight on the negative side of their operations. Thing is, while court case after court case has agreed with us that parody is a protected form of free speech, the corporations at the pointy end of our parodies tend to disagree. Exxon/Esso took us to court in France over alleged copyright infringement of their logo when we launched a campaign against them. We said it was free speech. The court agreed with us, and in a historic decision we won. But had that decision been left to Exxon/Esso, we would have been shut down. Nestlé's Kit Kat brand famously failed when it attempted to have our spoof video featuring its brand and critical of their support for rainforest destruction removed from YouTube for trademark violation. Hundreds of our supporters reposted the video on other sites and their own Facebook profiles. Eventually, YouTube's lawyers intervened and the video was restored. But it kind of noted that, under stricter IP laws, YouTube itself could have been shut down for hosting our Kit Kat video. Facebook could have gone dark for hosting the videos of its supporters, and Greenpeace.org could have gone dark worldwide. And Kit Kat owner Nestlé would have never been compelled by our supporters and their customers to revise its policy on palm oil procurement, a move which has struck a major blow to an industry which is mowing down orangutan habitat in Indonesia to plant palm trees. So Greenpeace has kind of been very vocal about opposing corporate censorship and about opposing draconian intellectual property laws. And I guess some of its kind of campaigns in recent years have been very much focused upon challenging the trademarks and the branding and the logos of key companies that it's running campaigns over. Being the father of an 8-year-old girl, I was kind of particularly keen on Greenpeace taking over Mattel and posting on the top of Mattel's building a kind of a big sign with Ken striking a very grumpy face and saying, "Barbie, it's over, I don't date girls that are into deforestation." Greenpeace kind of used Barbie and Ken in terms of its efforts to get Mattel to change its packaging. And they kind of ran a very strong campaign, which was both involved a kind of a protest outside Mattel's offices, and it was kind of combined with a social media campaign. But they were very much kind of focused upon using the kind of trademarks of Mattel to criticise Mattel and encourage it to engage in a more sustainable behaviour, kind of arguing creating the future of play shouldn't mean no future for rainforests. And in the face of such a fierce campaign, Mattel accordingly made representations that it would kind of change its practices in relation to packaging. Greenpeace, I guess, ran a very similar kind of campaign against Volkswagen, particularly in Germany, using Star Wars iconography. So they kind of ran a campaign entitled Volkswagen The Dark Side, in which they kind of had posters and they kind of shot images of Darth Vader up on the factories of Volkswagen. but the kind of action was very much kind of particularly focused upon trying to get VW to reduce their CO2 emissions, and in the end, Volkswagen was forced to cave in to the pressure that kind of took place from Greenpeace in that particular matter. Another kind of European battle involved Greenpeace kind of taking on the Finnish oil company, Neste Oil, and they kind of set up a website called Neste Spoil, and there was a kind of a battle over cyber squatting about whether or not that website was a fair use of the intellectual property of the oil company, or whether it was cyber squatting under the kind of their ICANN system for internet domain names and the Uniform Dispute Resolution System. In that kind of particular case, the arbitrators, including the human rights lawyer Professor Frederick Abbott, kind of found in favour of Greenpeace and held that, you know, in this particular case, free speech should prevail. So Greenpeace, I guess, is kind of quite interesting in terms of, you know, there are a range of kind of precedents that it's been involved in terms of battles over trademark law and free speech, and to a lesser extent kind of battles over copyright law and fair use. So that's my first case study in relation to Greenpeace. My second case study is on the Yes Men. And at this point it would be kind of useful if we could have the video of the Yes Men staging an action against the United States Chamber of Commerce.
So we're looking at Yes Men versus the United States, or
Can we load that up, please?
Can you? Sorry, I had to unmute. Yes Men versus the US Chamber of Commerce?
Yes.
Right.
Yes. First one, please. So the second case study really involves the Swiftian group, the Yes Men. The Yes Men, I guess, have been involved for many years in terms of engaging in identity correction. So they're particularly kind of fond of impersonating representatives of companies, governments and international institutions to criticise the absurdity of their discourse. So famously, they kind of pretended to be the World Trade Organization, and the World Trade Organization, they set up their own spoof website, and they kind of went off and do presentations for the World Trade Organization. They were also kind of involved in staging an event kind of criticising Bhopal, or the Bhopal disaster, and essentially they kind of did a fake press release and media presentations and saying that Union Carbide would make an apology and provide for proper compensation. But perhaps their kind of greatest kind of action was against the US Chamber of Commerce. Have we got the video?
Play. The sound is very poor. This is coming out of laptop. It's not patching through, which is on my Mac. Any Windows experts out there could we get the sound?
Okay, well, I'll just kind of talk over the top of it then.
Shall I play? Just play and see if people can hear it.
Yeah, I'll talk it through as we kind of go along. So in October 2009, the Yes Men staged a press conference pretending to be the United States Chamber of Commerce. The group announced that the Chamber had decided to support substantive legislative action on climate change. The Yes Men also kind of published a press release and established a website. Now, the United States Chamber of Commerce kind of famously is a very kind of powerful industry lobby group in the United States and had engaged in heavy lobbying domestically against climate change action, and they were all 2009, and essentially had really frustrated both domestic and international action in relation to climate change. And at the same time, they kind of took the position in terms of those debates that there should be very kind of strong protection of intellectual property rights. So in this kind of particular matter, the Yes Men really tried to punk the Chamber of Commerce and place a great deal of attention upon their activities. So the press release that they kind of put out was very much kind of focusing upon how the Chamber of Commerce had repented. So it's worth kind of giving you a little bit of a kind of a sense of the fake press release, given that we don't have audio there. The piece said, "We at the Chamber have tried to keep climate science from interfering with business, but without a stable climate there will be no business. We need business more than we need relentlessly high returns. There is only one way to do business, and that's to support a strong climate change bill quickly so that this December in Copenhagen, President Obama can lead the entire business world in ensuring our long-term prosperity." It also cheekily observed that the Chamber also calls on President Obama and the US Congress to cease subsidising old and failed technologies like the so-called clean coal hoax and to incentivise tried and true clean technologies in their stead. And it noted corporate social responsibility just won't cut it anymore, folks. Mother Nature means business, and we do too. So the Yes Men kind of dressed up and did a press release. Amusingly, a number of press agencies picked up the story before realising that it was a hoax. The press conference was kind of interrupted by a real member of the United States Chamber of Commerce, and there was a kind of a very funny exchange in which the Yes Men of the US Chamber of Commerce accused one another of being imposters and being frauds and complaining about who was the real Chamber of Commerce in that kind of particular matter. So it was a kind of a really effective and fascinating kind of episode, and I guess the Yes Men kind of brought to bear all their various performative strategies against the US Chamber of Commerce. They kind of engaged in identity correction, they did a hoax, they kind of infiltrated the US Chamber of Commerce, they engaged in media jacking, and they kind of engaged in culture jamming. In response, the US Chamber of Commerce took action, first under copyright law. So copyright law is a form of intellectual property that protects cultural creations like literary works and artistic works and musical works and dramatic works and sound recordings. But in this particular case, the US Chamber of Commerce issued a takedown notice in an attempt to silence the parody website, which was posted in support of the Yes Men's prank, mocking the Chamber's stance on climate change legislation. The takedown notice observed to the President of the Internet Service Provider that the website infringes the Chamber of Commerce's copyrights by directly copying the images, logos, design and layout of the Chamber of Commerce's copyright-protected official website, located at www.uschamber.com. The unauthorised exploitation of the Chamber of Commerce's copyrighted material constitutes a violation of the United States copyright law, including the Digital Millennium Copyright Act. In response, the Yes Men enlisted the Electronic Frontier Foundation, who are a civil society organisation based in San Francisco, who are very active in terms of providing both legal services and engaging in kind of policy debates over copyright law and privacy law, and also questions about surveillance and the NSA. The Yes Men were kind of represented by the brilliant lawyer, staff attorney Corinne McSherry. She responded that we are very disappointed the Chamber of Commerce decided to respond to political criticism with legal threats. The site is obviously intended to highlight and parody the Chamber's controversial views, which have sparked political debate and led high-profile members to withdraw their support from the Chamber. Her senior staff attorney, Matt Zimmerman, commented, "Parody is a well-established right, protected under copyright law and the First Amendment." And citing a number of copyright authorities, the Electronic Frontier Foundation commented that the website was clearly protected by the defence of fair use under copyright law. Plainly, the parody site was not a substitute for the original, nor did it invade in any licensing market for any of the Chamber's copyrighted works. Furthermore, the Electronic Frontier Foundation commented that a finding of fair use would be supported by the larger public interest. More broadly, the parody site serves the public interest by advancing political criticism and debate about the Chamber's position on global warming legislation, obviously of public concern as the Chamber purports to represent 3 million businesses of all sizes, sectors and regions. And the lawyers suggested that there were larger issues in the lawsuit about the protection of freedom of speech under the First Amendment. And they expressed disappointment that the Chamber of Commerce had chosen to take this approach, particularly in light of the Chamber's well-documented support for free speech. So, that was initially the copyright battle that kind of took place between the Chamber of Commerce, the Yes Men and the Internet Service Providers. Then the United States Chamber of Commerce followed up that action with an action under trademark law and a range of related kind of actions. So trademark law kind of provides exclusive rights into certain sorts of distinctive signs, and the United States Chamber of Commerce kind of wrote a very grumpy complaint saying that it brought its action to seek redress for the defendant's fraudulent acts and misappropriation of its valuable intellectual property. The defendants had a common plan to engage in acts that violated multiple laws. These acts deceived the press and public and caused injury to the Chamber while promoting the commercial ventures of certain of the defendants who trade under the name the Yes Men. The acts are nothing less than commercial identity theft, masquerading as social activism. These infringing and fraudulent acts are antithetical to public debate on important issues because they prevent the public and press from knowing the true position of the intellectual property owner whose trademarks and copyrights were used without permission, and they disguise the true motives of the persons who took that property. In short, such conduct is destructive of public discourse and cannot be tolerated under the law. So essentially they kind of brought, in addition to kind of copyright action, 8 actions for trademark infringement, unfair competition, trademark dilution, false advertising, cyber squatting, unlawful trade practices, publication of an injurious falsehood, prima facie tort. So they really kind of used a wide range of legal actions to try to challenge the Yes Men and seek compensation and other remedies in relation to the matter. But essentially they were kind of relying at essence upon the registered marks of the US Chamber of Commerce in relation to the US Chamber of Commerce, the spirit of enterprise, and its eagle and stars design marks. In response, the Electronic Frontier Foundation also defended the yes men against these arguments. And again, they kind of argued that the action was a brilliant piece of political theatre, but it had a serious purpose, calling attention to the Chamber's political activities. This is core political speech protected by the First Amendment. And really they argued that the First Amendment protects parody from trademark and other actions. And Corin McSherry for the Electronic Frontier Foundation argued that there should be a dismissal of the variety of different claims that have been made against the yes men for intellectual property infringement. And really the Electronic Frontier Foundation kind of emphasised that, you know, there were larger issues in the United States jurisprudence about the relationship between intellectual property and First Amendment expression, and they were concerned that the Chamber's opportunistic behaviour was really an attempt to silence its critics. And they received some support from another civil society group called the Public Citizen. And the Public Citizen emphasised that the yes men made use of the Chamber's marks only to further a purely political aim, not to promote any goods or services in competition with the Chamber. And I guess the action was also kind of significant because there were various other efforts at that kind of particular time to culture jam the United States Chamber of Commerce. So Bill McKibben's 350.org kind of ran a campaign called the US Chamber of Secrets, which used the iconography of Harry Potter and the Harry Potter series to criticise the US Chamber of Commerce. And they kind of had a whole website devoted to the US Chamber of Secrets, kind of going through the deep, dark history of the US Chamber of Commerce and its lobbying on a range of different issues. In the end this year, the yes men were finally triumphant. So, you know, in 2013, several years after the litigation was begun, the US Chamber of Commerce withdrew the action and got cold feet about it and kind of suggested that the controversy had passed. The yes men weren't going to leave that opportunity lie, and they kind of staged a press conference on the steps of the US Chamber of Commerce to kind of discuss the case and argued that the US Chamber of Commerce should keep going with the case because they were looking forward to winning it in court. Andy Bickelbaum of the Yes Men said, you know, the US Chamber knew this was our chance to challenge their silly claims, and since they claimed we had damaged them, investigate the details of their finances through the discovery process. And Andy said it's the height of rudeness to deprive us of this great opportunity. The other member of the Yes Men said the US Chamber's lawsuit represented the only time in 17 years that anyone has been stupid enough to sue us. This was the chance of a lifetime, and we profoundly deplore the US Chamber's about face. Far from being cowed by the litigation by the US Chamber of Commerce, the Yes Men have been even more active over culture jamming in relation to matters of environmental protection and climate change. And indeed have kind of set up their own Yes Lab to encourage culture activists around the world to engage in collective action in relation to culture jamming governments and companies. So there's kind of a litany of disputes that the Yes Men have since been involved in, but it's worthwhile kind of giving you a sense of what they've done. They kind of pretended to be the Canadian government at the Copenhagen climate talks and suggested that Stephen Harper's Canadian government really wanted a new agenda for climate change and world development and was not that keen on the Keystone oil pipeline and tar sands. The Yes Men kind of took apart Chevron's We Agree campaign and kind of spoofed it and encouraged people to do their own spoofs around the world on the Chevron We Agree campaign. And they've also kind of taken action against General Electric and Peabody. And they teamed up with Greenpeace to criticise Shell and its enthusiasm for going drilling in the Arctic. And they kind of created subverts, like an ad saying, in order to survive, we all have to push our limits. Let's go and mine the Arctic. And in the past month, the Yes Men have been involved with the Yes Lab in disrupting TransCanada's Keystone XL pipeline community consultations. So essentially, they have set up their own lookalike activists to engage in community consultations. And wherever TransCanada goes, and the community activists go along as well, giving their own one-on-one discussions with members of the community about what should happen in relation to the Keystone XL pipeline. So they've been kind of doing lookalikes, the only difference being that they have kind of Save Canada name tags and brochures. And instead of promoting the pipeline, the Save Canada reps communicate risk. I think the dispute between the Yes Men and the US Chamber of Commerce have a lot of larger kind of issues in terms of policy issues, in terms of copyright law and trademark law, internet domain names. I guess it also kind of raises large issues about personality rights and laws about impersonation. The Yes Men, for their purposes, have kind of stressed that one shouldn't be afraid of the law. So Andy Bickelbaum of the Yes Men did a contribution to the Beautiful Trouble book, and he emphasised that one should use the law, don't be afraid of it. Remember, don't be afraid of suits, law or otherwise. And his kind of perspective was that the law is a funny thing. Sometimes the Yes Men ask lawyers, before we do anything particularly dangerous, we get one of two answers. Don't do it, it's illegal, you get sued. Or awesome, it's probably legal and besides you're righteous in the court of public opinion. The awesomes are almost always right for two reasons. In the United States, at least, the law does in fact protect freedom of speech to a very high degree. And secondly, corporations don't sue because they know how it can blow back on them, and they want to avoid having yet more egg on their big, blank, mechanical faces. So I think the dispute between the Yes and the US Chamber of Commerce is very kind of interesting. Unfortunately, we don't have something as clear-cut as a precedent because the matter kind of was drawn before it kind of reached a court case. So for the rest of the evening, I just have a few more kind of case studies with varying different kind of results. I think the Yes truth. This kind of dispute kind of took place a year after the battle between the Yes and the US Chamber of Commerce in 2010. And it essentially involved an anonymous youth climate group putting out a fake press release on behalf of the Koch brothers. The Koch brothers are famously the Kansas corporation that owns multiple companies involved in a wide variety of industries, but particularly including oil and coal, and they've been kind of heavily involved in funding think tanks, funding policy organisations to oppose law reform in terms of United States congressional action on climate change and also international action. Much like the Yes Men, the Youth for Climate Truth put out a fake press release, and this press release stressed that based on recent internal evaluations of Koch Industries' priorities, the company will be restructuring its support of climate change research and advocacy initiatives and will discontinue contributions to groups whose positions on climate change no longer match those of the company's leadership. So again, you kind of have this kind of press release that was kind of designed to kind of flip the position of a noted opponent to action on climate change. The industries were very upset about this fake press release, and they filed a complaint. They kind of noted that they're a firm believer in our nation's First Amendment and the right to free speech, but nonetheless there was a need to file the lawsuit in response to a willful act of identity theft, theft of intellectual property, and impersonation that extends beyond the boundaries of free speech. And they complained that it was a publicity and fundraising stunt perpetrated with the intent to deceive and confuse the public and disrupt and harm the industry's business and reputation. And they kind of accused the anonymous pranksters of violating federal laws on trademarks, unfair competition, cyber squatting, and violations of the Computer Fraud and Abuse Act. And moreover, it brought action against the two Utah-based domain hosting companies called Bluehost.com and FastDomain.com to release the identities of those who'd registered the website address used to send the prank press release. I guess a further complication of this particular case was that the company didn't know the identity of the climate change activists, so they tried to get the court to identify who were the Jane Does or the John Does who did the press release in this particular action. In response, the civil society organisation Public Citizen appeared on behalf of the defendants Youth for Climate Truth and tried to quash the coach industry subpoenas and prevent them from using information that they had extracted from the domain hosting companies. And they argued that trademark protections are aimed at commercial uses and not political speech, and that the First Amendment fully protects political speech. And in the 2011 case of Coach Industries Incorporated versus John Doe's, the Youth for Climate Truth were triumphant. It was a really kind of helpful 2011 precedent. The judge was Justice Kimball, and firstly the judge kind of dealt with the questions about trademark law, and the judge kind of emphasised that, you know, the press release only addressed Koch's views on political issues. It didn't address into Koch's commercial goods and services, and at most the press release related to how Koch spends its profits and with whom it does business. And the judge, in a kind of a really kind of important nuggety ratio, emphasised that the Lanham Act, which is the US Trademark Act, regulates only economic, not ideological or political competition. The competition in the marketplace of ideas is precisely what the First Amendment is designed to protect. The judge also rejected the arguments about that there had been cyber squatting. The judge also rejected arguments that there had somehow been an abuse of the Computer Fraud and Abuse Act. And moreover, the judge kind of defended the anonymity of the Youth for Climate Youth and stressed that, you know, if internet users could be stripped of their anonymity by a civil subpoena, enforced under the liberal rules of civil discovery, this would have a significant chilling effect on internet communications and thus on basic First Amendment rights. The Youth for Climate Truth were very triumphant about the ruling. They put out a statement saying that the court's ruling is a victory for anyone like us speaking out against corporations that use their fortunes to mislead the public about the serious dangers of climate change. The judge's verdict is a blow to Koch's efforts to scare critics of their multi-million-dollar climate denial campaign into silence. We will never go public, we're not in it for the personal fame, just trying to stop the Koch brothers and the Koch industries from lying about the true threats from climate change. Public Citizen also kind of emphasised that the ruling is an important victory for free speech online. So I think it's worthwhile comparing those case studies on Greenpeace and the S-Men and Public Citizen with the much more depressing case study of Bidder 70 involving the climate change activist Tim de Christopher. So the...
To interrupt for a second.
Yeah.
I brought up one of those Yes Men videos on another computer, hoping that the sound worked. Is it worth? Would you like to?
We can view it at home.
Play just keep moving.
I think I'll just kind of keep moving at this stage. So there's been recently a kind of really interesting documentary done about this case called Bidder 70, which is well worth catching. Just kind of briefly kind of discussing the kind of controversy. Tim de Christopher, known as Bidder 70, protested a Bureau of Land Management oil and gas lease auction by successfully bidding on 14 parcels of land without any intention of paying for the purchases. Tim de Christopher was subjected to legal action, and he kind of emphasised in this particular case that he had been subjected to selective prosecution. And it very kind of much echoes of the kind of Moylan dispute at the moment. Tim de Christopher kind of argued that the rule of law is dependent upon a government that is willing to abide by the law. Disrespect for the rule of law begins when the government believes itself and its corporate sponsors to be above the law. He noted that the prosecution had claimed that the seriousness of my offence was that I obstructed lawful government proceedings. In his view, though, the auction in question was not a lawful proceeding, and he noted that there were kind of larger questions about the Bush administration selling off oil and gas leases in a fire sale event at the kind of the lame duck period of the Bush administration. He emphasised that the law was put into effect to mitigate the impacts of catastrophic climate change and defend a livable future on this planet. The law was about protecting the survival of young generations, and that was a kind of a big deal, and it's a big deal to me. If the government is going to refuse to step up to that responsibility to defend a livable future, I believe that that creates a moral imperative for me and other citizens. And, in his pitch, he emphasised that my future is being traded for short-term profits, and I take that very personally. Until our leaders take seriously their responsibility to pass on a healthy and just world to the next generation, I will continue this fight. De Christopher was convicted of an indictment and sentenced to 2 years. The documentary is kind of really interesting in dealing with kind of the legal argument that kind of took place. De Christopher and his lawyer complained vociferously that they weren't allowed to run particular arguments before the jury in this particular case, so they were kind of concerned that they were very much kind of confined to the legal offence that was being argued and weren't allowed to make larger arguments about selective prosecution and retaliatory sentencing and climate change. De Christopher, on his appeal, tried to raise those issues again, but the judge noted that, the defendant's statements that he would continue to fight, in his view, that was found to break the law were highly relevant to the sentencing factors. De Christopher had been hopeful that he had been let off with probation, but he was sentenced to a term of 2 years imprisonment, and he was recently released from federal prison after 21 months of imprisonment, and he's kind of currently gone off to join divinity studies. Bill McKibben, I think, was very much kind of influenced by the De Christopher trial and the De Christopher case. He noted that Tim has shown the power of civil disobedience to shine a light. The government should be giving him a memorised sentence, and in time this will be recorded as an early battle in the centuries-long fight for a livable climate. Just in case the federal government thinks that it's intimidating people into silence with this kind of prosecution, think again. In fact, this is precisely the sort of event that it reminds us why we need a real mass mobilisation to stop the climate crisis. Tim took a brave and lonely stand. It's time to make sure that in the future, bravery comes in bigger quantities. And I think McKibben was kind of influenced in a number of ways by the De Christopher action. I mean, at his recent tour of Australia, McKibben kind of emphasised that there was a need for collective action in relation to climate change, and highlighted both the strengths and risks involved in terms of civil disobedience actions. And I guess he also kind of expressed a desire for elders to kind of stand up and kind of take action in relation to climate change matters, and not merely leave it to youth or students or college students to kind of bring civil disobedience actions or culture jamming actions. I think the case of De Christopher is also kind of interesting in the sense that it shows that a lot depends upon how judges view civil disobedience, culture jamming matters, and how they perceive matters dealing with hoaxes. I think in some ways it's very hard to reconcile the very hard line taken in something like, say, the De Christopher case with the much more tolerant view taken of, say, the Youth for Climate Truth, also from Utah. So, I mean, thinking about those precedents, I think it's worthwhile finding to think about the current battle over the Whitehaven case and the matter of Jonathan Moylan. So Professor Sarah Joseph from Monash University has done a really nice little overview of the Whitehaven hoax battle called Rat Bag Act or Legitimate Protest. She noted that on the 7th of January, environmental activist Jonathan Moylan put out a fake press release purporting to convey a decision by the ANZ Bank to withdraw its $1.2 billion loan to Whitehaven Coal for environmental reasons. As a result, shares in Whitehaven plunged by 314 million before covering to pre-hoax levels. As a result, Moylan was being investigated by ASIC for breaches of corporations law in allegedly engaging in misleading and deceptive conduct, which stabilises the stock market. She noted that he could face jail time, and she noted that his intention was not to cause people to lose money, that he was sorry, and that he was prepared to face the consequences. Moylan explained that he sent out the press release that ANZ should have sent, and the stunt was meant to highlight ANZ's dirty line for a project which he believed will unduly harm the environment. Others supported his actions as highlighting the immorality of financing new coal projects in the face of the dangers of climate change. I think the action is kind of very interesting in terms of it's led to a great legal and public and media debate about how to interpret his actions, and there's been a great deal of debate about the nature of the hoax. And for me, I guess it kind of reminded me that, you know, Australia has a kind of a long-standing tradition of satirists engaging in impersonation, with notable examples being, you know, Barry Humphries and Norman Gunston and Max Gillies and John Clark. And there's a long history of literary hoaxes in Australia, everything from the O'Malley hoax on the Angry Penguins to the much more recent Helen Demidenko, Helen Darville impersonation hoax. And I kind of, thinking about the Jonathan Moylan kind of dispute, I was kind of reminded of a conversation I had with John Clark, who noted that back in 2001 there was a High Court case on defamation and impersonation, and the Chief Justice at the time, Chief Justice Gleeson, kind of remarked in a hearing that there is a man called John Clark who is very entertaining on television, and he attributes outrageous statements to public figures, and it's very amusing to watch him. And he said that he'd be surprised to see him sued for injurious falsehood, so obviously made up his statements. So I guess there's a lot of debate about the nature of the actions engaged in by Jonathan Moylan. Was it an act of civil disobedience? Was it a spoof? Was it culture jamming? Was it rat bag mischief? Was it misleading and deceptive conduct? Or was it corporate fraud? Jonathan Moylan, for his part, commented that the action was a spoof. He said, "We think it is a bit like the Chaser getting into APEC or the Yes Men announcing that Union Carbide had shut down." In July 2013, ASIC charged Moylan with the offence of breaching section 1041E of the Corporations Act through the making of false or misleading statements. He faces a maximum fine of up to 490,000 Australian dollars and imprisonment for up to 10 years. The provision of the Corporations Act, I guess, is quite a strict provision. So I guess it's a little bit different in terms of the area of law that's kind of implicated by the hoax. So a lot of my earlier case studies were really dealing with matters of trademark law and copyright law and internet domain names, and they all have public interest defences. The kind of provision of the Corporations Act is much more strict in terms of the offence. So Section 1041E deals with false or misleading statements, and it emphasises that a person must not, whether in this jurisdiction or elsewhere, make a statement or disseminate information if A, the statement or information is false in a material particular or is materially misleading, and B, a statement or information is likely to induce persons in this jurisdiction to apply for financial products, or to induce persons in this jurisdiction to dispose of or acquire financial products, or 3, to have the effect of increasing, reducing, maintaining or stabilising the price, trading of financial products on a financial market operated in this jurisdiction. And when the person makes a statement or disseminates the information, the person does not care whether the statement or information is true or false, or the person knows or reasonably to have known that the statement or information is false in a material particular or is materially misleading. So it's quite a kind of particular offence that Moylan is going to have to navigate with his lawyers in that matter. I guess, you know, the decision to kind of prosecute Moylan was welcomed by those outraged, misled or embarrassed by the Whitehaven coal hoax. So particularly some of the members of the media, members of the fossil fuel industry, some of the conservative members of politics were very keen on action being taken. Defenders of Moylan, like Bernard Keane, have accused ASIC of double standards. And they kind of have argued that really ASIC has been busy chasing pranksters while they haven't kind of taken action on much more serious and important matters, dealing with insider trading, dealing with the current kind of controversy over latent holdings, dealing with some of the controversies that have been taking place in relation to fraud in relation to currency. And Bernard Keane, in particular, in a kind of a piece called John Gray, Jonathan Moylan, and A Tale of Two ASICs, kind of noted that, you know, while ASIC was waiting for a minimal fine for insider trading, it was ramping up its pursuit of Jonathan Moylan, the man behind the Whitehaven coal hoax. And it kind of noted the kind of the inconsistency in terms of, you know, the pursuit of Moylan compared with, you know, action with much more serious matters. I think that's kind of a really important question about rule of law. And there was a very similar theme, I think, kind of appearing in relation to the Bidder 70 controversy. So Robert Redford and Bill McKibben and others in the Bidder 70 documentary kind of highlight the inconsistency in terms of the Obama administration kind of bringing action against Timothy Christopher over, you know, the Bush administration's dodgy oil leases and gas leases, and not necessarily kind of taking action in terms of, you know, the global financial crisis and a lot of the conduct that was kind of taking place in Wall Street. So I think it's going to be a really interesting controversy. You know, some have been disappointed that the matter's been moved to the New South Wales Supreme Court. Might make things much more expensive, and it seems that Jonathan Moylan has been very reliant upon crowdsourcing to kind of raise funds to defend himself. I think the plus of going to the Supreme Court of New South Wales is that you might have a more sophisticated discussion in a superior court about kind of the issues raised by this particular matter. So to sum up for the evening, you know, really I've kind of looked at some of the battles by the fossil fuel resistance and engaging in ad busting and culture jamming and hoaxes. I guess there's been quite a variety of different legal responses to such forms of environmental activism and climate activism. So first of all, I kind of talked about Greenpeace and its use of ad-busting strategies, particularly dealing with companies like Mattel and like VW. And I emphasise that they've taken a very kind of strong stand in terms of the large debates about intellectual property policy, about the importance of fair use and freedom of speech. Second of all, I talked about the battle between the US Chamber of Commerce and the S-Men, and how Corinne McSherry from the Electronic Frontier Foundation very masterfully defended the yes-men against charges of copyright infringement and trademark infringement, particularly highlighting how parody is protected as a fair use in the United States, and how the activism of the yes-men raised larger questions about constitutional law and freedom of speech under the First Amendment. Third, I looked at the really interesting precedent of the Youth for Climate Truth, in which the judge rejected various complaints under intellectual property law by a big fossil fuel entity, and also recognised the importance of freedom of speech and recognised the importance of protecting the anonymity of climate change activists and environmental activists. And then I kind of contrasted that with the much more kind of draconian case of Bidder 70, in which Tim Christopher was charged and sentenced and sent to jail for his bids in relation to oil and coal leases. And then finally, I kind of finished up talking about the Australian controversy in relation to Jonathan Moylan and the Whitehaven coal case and the larger questions that raised about climate change and culture jamming and civil disobedience. And I guess that particular dispute has also had spin-off disputes as well. I mean, there was a kind of a very concerted campaign against ANZ after that matter, with ANZ is out of order, which heavily relied upon the trademarks of ANZ and involved out of order notices being put up outside banks and ATMs of ANZ. So I think it's really kind of an interesting area of legal and political and cultural politics in terms of battles over climate change, civil disobedience and culture jamming. Sorry we couldn't play the video, so I'll put up a PDF of the slides that I normally have to accompany the talk, and if you're interested in those, you can have a look at them for yourselves. But it's probably time to have some questions.
Thank you very much, Matt. We're a bit short on time. We're going to take questions till about 8, or maybe later. That clock's a little fast. We've got one question down the front here.
Yes, we don't have the First Amendment here in Australia. So what is the future of political satire, like in this country, you think?
You'll have to repeat the question for me.
Okay. Sorry.
We don't have the First Amendment here.
Yes, I'll have to repeat it.
Okay.
Okay, we don't have the First Amendment in Australia, so what is the future of political satire in Australia?
Look, that's a really good question. Under copyright law, under Australian copyright law, we have a defence of fair dealing. And for many years, I kind of campaigned to try to get the defence of fair dealing expanded. So in 2006, there was a defence of fair dealing for parody and satire. At the moment in Australia, there's a current debate about whether we should have a general defence of fair use under copyright law. The Australian Law Reform Commission is currently holding an inquiry on that topic. And that's really kind of quite important for activists who want to engage in criticism of copyright works. So if you're interested in making a submission or interested in the topic, have a look at the Australian Law Reform Commission's discussion paper. Its final report should come out soon. Australia doesn't have the First Amendment, but we do have an implied freedom of political communication. And there has been the odd dispute involving culture jamming that has invoked questions about constitutional protection. So during the Australian bicentenary there was a guy called Davis, who was an Indigenous protester who made T-shirts like 200 years of oppression. And the Bicentennial Authority kind of brought an action against him. And the High Court of Australia rejected that action in part, talking about the importance of political dissent and political discussion. So, you know, the implied freedom of political communication, I guess, has been kind of sometimes read in quite a limited way of late, but perhaps that could have some impact in relation to copyright matters. Other jurisdictions have had some really interesting constitutional precedents on trademarks and culture jamming and freedom of speech. So I've written about a case in South Africa, and Justice Albie Sachs wrote this beautiful judgment in this case involving Laugh It Off Promotions and a beer company, talking about the need for laughter in constitutional law and how it was particularly important for trademark law not to be used to silence or suppress political speech. But I guess there are kind of important questions there about, well, what safety valves are in place in terms of regimes like intellectual property, and how does constitutional law work in terms of that implied freedom of political communication?
Thanks.
But excellent question.
Do we have any more questions? No more questions? Yes?
The term culture jamming is fairly new to me, and I think I get it from the context, but could you have a go at defining it for me, please, or explaining it more?
Yes, Matt, could you define culture jamming for us, please?
Well, I mean, I think culture jamming, I guess, has a kind of a long history. I mean, I think culture jamming is very much kind of focused upon jamming a cultural transmission. So, you know, historically it's been very kind of focused upon advertising, particularly advertising by corporations or governments. So to culture jam is to kind of disrupt or jam that transmission and kind of send out a different form of cultural expression. So, you know, the collection Beautiful Trouble is really systematic in having a look at all the varieties of techniques and strategies that exist in relation to culture jamming. And I mean, I think that the book really highlights a great diversity and array of different kinds of creative action that can take place. So I guess the different activists that I've looked at today have used slightly different sorts of tactics, but really there's a whole range of tactics in that kind of toolbox. So, you know, there are vigils and banner hangs and blockades and forms of creative disruption, and you know, culture jamming, I guess, is very much targeting messaging or branding. You know, there's direct action, there's guerrilla theatre, there's eviction blockades, you know, there's flash mobs, there's general strikes, there's guerrilla projection, there's hoaxes, there's identity correction, there's image theatre, there's mass street action, which, you know, 350.org are very keen on. There's occupations, like, say, Occupy Wall Street. There's public filibusters. There's strategic non-violence. So I guess there's a variety of different kinds of forms of cultural activity that can be used in terms of activities that might come within the framework of culture jamming. But from my perspective as an intellectual property academic and scholar and historian, I've always been very interested in actions against trademarks or copyright, particularly for parody and satire and you know, for other artistic and political purposes. So hopefully that kind of just gives you kind of a sense of what culture jamming is and the kind of array of techniques and strategies that it involves.
Do we have any more questions? In the middle there?
Is the frequency of these activities increasing over time?
Is the frequency of these activities increasing over time, do you think?
Well, I think it's become much more kind of supercharged in kind of the digital era. So, you know, it used to be a much more kind of laborious activity engaging in culture jamming. So, you know, the Yes Men, for instance, started off doing the Barbie Liberation Front, you know, swapping the voice boxes of G.I. Joe and Barbie and sending them out in the world. But, you know, these days, you know, copying and remixing and transmitting work has become much easier. So, you know, adbusters had a lot of problems historically trying to get their counter adverts broadcast. So, you know, a lot of the Canadian mass media organisations kind of refused to kind of broadcast the videos that they kind of came up with. You know, these days, it's much more easier to kind of run social media campaigns using, you know, YouTube and Twitter and Facebook and a variety of other services to communicate a kind of a culture jam and then transmit that far and wide. So, I mean, I think, you know, it's much easier to also engage in collective action. So, you know, the Yes Men these days are very good at enlisting a wide range of different collaborators and affiliates to run actions all over the world. And, you know, 350.org, you know, can show how, I guess, an array of different kind of cultural action can be encouraged in a very decentralised way. But, you know, I think there are kind of a greater adoption of, you know, those sorts of techniques and strategies, you know, in terms of the current Web 2.0 environment. It's much more easier to do, I think. Much easier to kind of put up a hoax or kind of engage in a culture jam or engage in kind of impersonation in terms of the current digital environment.
Thanks, Matt. We've got time for one more question, I think. Up the back.
What about Google bombs?
What about Google bombs?
Yeah.
Is that something you know?
Well, I mean, bombing is a kind of long been a kind of a tactic or a strategy that's been kind of used in relation to a wide range of activities. So much more traditionally, I guess, Shell had kind of sponsored a big Grand Prix, and there were kind of Greenpeace had arranged it so these banners had kind of pushed up. So, you know, for the big photo shoot and the big shaking of the champagne, you had Greenpeace kind of jamming that transmission. I guess Google bombing or Google washing really refers to the practice of creating a large number of links that cause a web page to have a high ranking for searches, sometimes for comic or satirical purposes. I guess there are, you know, a range of different motivations for doing that. And I guess, you know, it's a kind of a form of tactical media, I guess. So you could use it, for instance, in terms of a combination. If you can't create a website and wanted to redirect traffic, that might be a way to kind of redirect traffic. You know, Google itself is not necessarily very happy about such kind of strategies, but, you know, I guess it's kind of one kind of particular strategy that has been kind of used. But to me, I mean, I think it is, you know, it could be used particularly to kind of subvert, you know, social media campaigns by some of the fossil fuel industries to kind of redirect traffic or change traffic. And, you know, often that there's a kind of a desire to disrupt those transmissions by doing that. But I guess that's kind of one of a number of different kind of strategies that are used. But, you know, media bombing, whether traditional or, you know, dealing with search engines, has long been a kind of a tactic that's been kind of used to disrupt the public relations of companies.
Thanks very much, Matt. Would you all please put your hands together for Matt?
So, thanks very much. If you're keen on seeing the videos, I have a short piece of that talk called Colin Court, which is on the conversation. It kind of has links to the key videos for the Yes Men dispute, and it has a trailer for the Bidder 70 documentary, and it also has some of the interviews with Jonathan Moylan. It's kind of a short little snappy version of that bit of the talk. But thank you very much, Melbourne. Good to have a chat to you this evening on matters about the fossil fuel resistance, intellectual property, climate activism and culture sharing.
Thanks for your time, sir. I'd just like to say that Beyond Zero Emissions is mostly a volunteer organisation. People who have put on this discussion group tonight are all volunteers. BZE is supported by donations from individuals. We don't take money from politics or corporations, so we continue to speak out without risk of upsetting vested interests. It's expensive to run the organisation, and if you would like to donate to the organisation, what we'd really like is for people to become what we call baseload supporters, where you put in a certain amount of money a month. There's some forms on the table just outside the door. Next month we've got Patrick Herbst, lead author of the Zero Carbon Australia Stationary Energy Plan, to present an update on the plan following similar 100% renewable scenarios from the Australian Energy Market Operator and the University of New South Wales. Now that talk will be on the second Monday of the month, for next month, because of the fact that it's before Cup Day. And that's it. Thank you all for attending.